Hello and welcome to Onassis Law, and in this video we are going to see the introduction relating to Indian Contract Act 1872. Well, before understanding the nature of the obligations falling under this act, we need to understand what is a contract. For example, today I promise that on 13th of November I'm going to post an important video on this act, and on 13th of November, suppose I don't upload any of those videos. So the question arises whether you are legally entitled to enforce this obligation on my part. Secondly, is it a valid contract or not? So, what is a contract? The answer is obviously no to this question. But the thing is, what is a contract then? So, contract is a legally binding agreement between two or more persons by which the rights are acquired by one or more person to the acts or forbearances on the part of the other party. So this act was basically drafted under the chairmanship of Lord Ramilly and was it came into enforcement on 1st of September 1872. It has overall total 10 chapters and 238 sections. In fact, earlier it had two more chapters, chapter 7 and chapter 11. But later on, those chapters were repealed, and chapter 7, after being repealed, was enacted in the form of Sale of Goods Act. And similarly, chapter 11, that was repealed, was also enacted in the form of Indian Partnership Act 1932. Now, Indian Contract Act is a set of civil and substantive law, or it is falling under the branch of civil law and also the substantive law. So, what is a substantive law? Substantive law is that law which deals with the determination of the rights and obligations of the parties. So here, if there's a breach of a contract between the two parties, then the court has to see that which of the parties is entitled to get the compensation and which of the parties is legally obliged to pay that compensation to the other party who is having the right to claim that compensation. So, Indian Contract Act is something which deals with only the general principles of contract. General principles means it is not dealing with the specific principles. If you have to deal with the immovable property, then you will go into Transfer of Property Act. Suppose you have to sell a property, or you have to mortgage a property or whatever. So you will be dealing with Transfer of Property Act, which is also dealing with the contractual obligations. But that has to be in conformity with the Indian Contract Act 1872. This act is again a non exhaustive act, meaning thereby that it is not dealing with the entire or the whole law of agreements. That means where the parties are entering into some agreement but they are not legally obliged to do it, or they are not legally intending to perform their part. In that case, although it is an agreement, but it is not a legally bounding agreement or legally binding agreement. So you can say that in such a case, Indian Contract Act which is not applicable to such kind of relations. Indian Contract Act is again a legal framework for trade and commercial activities, social and familial contracts. Now, familial contracts means, for example, you must have heard about the Muslim marriages. So, Muslim marriage is a contract. So, in those cases also, you must have heard about kubula, 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 and all those things. So, there has to be an offer, and then which has to be accepted and has to be again under some consideration. So, all the essentials of a valid contract has to be fulfilled in those cases as well. Again, this act deals with only such relations which are voluntarily created civil obligations. That means it will not be including the law of torts or law of trusts, etc. What does that mean? That means if two parties are entering into a contract, then it has to be done voluntarily. For example, if it is a marital relationship under personal Muslim personal law, in that case it is a contract. So what is a contract? Contract again requires that the parties are competent and they are entering into that contract voluntarily, which has to be free from the influences of fraud or coercion or undue influence or mistake or misrepresentation, etc. So that's why it is saying that this act deals only with such relations which are voluntarily created civil obligations, and it does not include the laws like law of torts or law of trust. Now, law of torts means, for example, if there is, suppose there is a wrongful act on the part of my side, suppose I create a nuisance to my neighbors. So the neighbors would be entitled to get the damages for the nuisance that I created for my neighbors. So in that case, this is a civil wrong where the damages are unliquidated, they are not predetermined. So under the contractual law, the compensation is something which is of liquidated nature, which has to be predetermined. So in that sense, it is saying that it only deals with such relations which are voluntarily created civil obligations, and it does not include the law of torts or law of trust, etc. I hope you could understand the basics about the contract under the Indian Contract Act. Thank you so much for watching this video.